So this matter is coming up for judgment. The petitioner being aggrieved by the substitution of the 8
responses, learned submissions by counsel, and the applicable law. The issues for determination are as follows. 1. Whether it is mandatory to file an affidavit in support of a constitutional petition. 2. Whether the first respondent made regulations under Section 42(2) and Section 73(4) of the Basic Education Act. 3. Whether the first respondent acted contrary to the law by relying on Basic Education Curriculum Framework 2017 and Sessional Paper Number 1 of 2019 without amending an amendment to Section 41 of the Basic Education Act. Issue number 4, whether the petitioner is guilty of laches. Section 42(2) of the Basic Education Act provides that 2. The Cabinet Secretary, in consultation with the National Education Board and other relevant stakeholders, shall make regulations prescribing an appropriate structure for education and training. Section 73(4) of the Basic Education Act provides policy and guidelines on curricula. The Cabinet Secretary shall, in consultation with relevant stakeholders, make appropriate regulations to implement the provisions of this section. Section 95 of the Basic Education Act reads as follows. Regulation 2. Without prejudice to the generality of subsection 1, the Cabinet Secretary may make regulations to provide for A. An appropriate structure of education and training, B. Incentives to learners, teachers, and non-teaching staff, C. Discipline corrective measures and expulsion of to facilitate compliance, D. Admission, progression, and transfer of learners, E. Integration of the madrasa, duksi, and pastoral programs of education into the formal education system as appropriate to improve access and retention. F. To secure appropriate institutional linkages and relative autonomy of the Kenya National Commission for United Nations Education, Scientific and Cultural Organization to enable it to promote education through culture, natural, science, social, and human science, and information and communication technology. The petitioner's case is that there are no regulations made as envisaged under Section 73(4) of the Basic Education Act No. 14 of 2013. Therefore, that the implementation of CBC was done contrary to the law. This contravention is not rebutted by the respondents. From the material before court, it is a fact that there are no regulations under Section 73(4) of the Basic Education Act. We have, however, noted the existence of Basic Education Regulations 2015 made by the Cabinet Secretary under the powers conferred by Section 95(2) of the Act. It is instructive to note that the CBC was rolled out in the year 2018 during the subsistence of the above regulations. Despite the absence of regulations under Section 73 of the Basic Education Act, and in view of the regulations under Section 95, the second respondent did not develop the curriculum in a vacuum. We have grappled with the question of the effect of the absence of regulations under Section 73 of the Basic Education Act. In the case of Walter Osapiri Barasa versus Cabinet Secretary, Ministry of Interior and National Coordination, and 6 others, 2014 EKLR, at paragraph 127, the judge, while seeking guidance, cited the case of Republic versus Home Affairs ex parte Sitamanze 20082 EA 323. This court made a determination on when the court can intervene with the mandate of a minister exercising his discretion under rules. The court held that it would be wrong to intervene with the merits of the minister's decision except in the following circumstances. 1, where there was an abuse of discretion. 2, where the decision maker exercised his discretion for an improper purpose. 3, where the decision maker is in breach of the duty to act fairly. 4, where the decision maker has failed to exercise statutory discretion reasonably. 5, where the decision maker acts in a manner to frustrate the purpose of the act, donating the power. 6, where the decision maker fetters the discretion given. 7, where the decision maker fails to exercise discretion. And 8, where the decision is irrational and unreasonable. Further, in the present case, the minister has not exercised his discretion to make regulations under Section 172 and 173 ICA. Thus, borrowing from the Simanze case, I can readily think of some basic criteria which would underpin an action to impugn such failure of the minister. The judge went on to say, in my view, some of the facts which the petitioner would have to prove include that the failure to make such regulations, A, has resulted in a failure to realize the intention of the act, or B, results to an impediment in the exercise of fundamental rights or freedoms of the petitioner, or C, results in a situation so unfair, irrational, or unreasonable that any reasonable person in the minister's position would, in the circumstances, readily have made such regulations. Finally, D, amounts to a failure of a glaring and fundamental duty of the minister, which the court would be entitled to remedy with an order to compel him to make such regulations. Following from the above holding, the petitioner needed to prove whether the omission by the first respondent to make regulations resulted in a failure to realize the intention of the Basic Act or was an impediment to the intention of fundamental rights or freedoms of the petitioner. This burden has not been discharged, there being no evidence by way of affidavit or otherwise. We have further interrogated the issue before us, and we are satisfied beyond doubt that the doctrines of proportionality, the best interest of the child, the public interest, balance of convenience, and prejudice are applicable in this matter. The first main issue which is critical is the best interest of the child. What would be the effect of invalidating the implementation of CBC altogether on the child who since grade 2 is now in grade 8 has only known this system? Question. How will it affect the child psychologically? Question. Will it be in the best interest of the child to expect the child to completely forget and adopt a new curriculum altogether? The Constitution of Kenya 2010, under Article 53(2), provides as follows. A child's best interests are of paramount importance in every matter concerning the child. Section 8 of the Children Act 22 echoes this constitutional imperative as follows. Best interest of the child. In all actions concerning children, whether undertaken by public or private social welfare institutions, courts of law, administrative authorities, or legislative bodies, A, the best interest of the child shall be the primary consideration. B, the best interest of the child shall include but shall not be limited to the considerations set out in the first schedule. 2, all judicial and administrative institutions and all persons acting in the name of such institutions when exercising any powers conferred under this Act or any other written law shall treat the interests of the child as a first and paramount consideration to the extent that this is consistent with adopting a course of action calculated to A, safeguard and promote the rights and welfare of the child, B, conserve and promote the welfare of the child, C, secure for the child such guidance and correction as is necessary for the welfare of the child and in the public interest. 3, in any matters affecting a child, the child shall be accorded an opportunity to express their opinion, and that opinion shall be taken into account in appropriate cases, having regard to the child's age and degree of maturity. 4, the Cabinet Secretary shall issue guidelines to give effect to the section. In the Supreme Court case MAK versus RMAA and 4 others, petition number 2 in bracket E003 of 2022, 2023 KESC 21 KLR Civ 2 of 2nd March 2023, the Supreme Court held as follows. The Children's Rights Legal Regime, the Constitution, the Children Act repeal, CRC, and the African Charter on the Rights and the Welfare of the Child emphasized the centrality of the best interest of the child. The best interest of the child was determined by the circumstances of the case as they specifically related to the child. That compromised the principles that That comprised the principles that the child's right to survival, the protection, participation, and development above other considerations, and including the rights contemplated under Article 53 of the Constitution. The focus had to be on the child and what was best for the child. There was no hierarchy in the children's right provided for under the Constitution. All the rights provided under Article 53 of the Constitution were in the child's best interest. The best interests concept was further strengthened by being the paramount consideration. The best interests of the child were to be the determining factor when making a decision on the child. It was against that aspect that the parental rights ought to be balanced. No right should be compromised by a negative interpretation of a child's best interests. The record did not provide any cogent evidence of the English court balancing between parental rights and the best interest of the child principle. Further, in the persuasive case of L&M versus A Attorney General and another, 2021 EKLR, the court cited with approval the case of MAA versus ABS Civil Appeal number 32 of 2017, where the court held as follows. The interest of the child is first and paramount, and everything must be done to safeguard, conserve, and promote the rights and welfare of the children. It therefore follows that the best interest of the child is a first and paramount consideration of the child. A court must do everything to safeguard, conserve, and promote the rights and welfare of the minor herein. It is evident that the CBC has already been rolled out, and over 8 million children are undergoing the new system. Teachers have undergone retooling, and teaching materials and aids have been prepared and distributed. Classrooms have been built to cater for junior secondary school learners. The government has made budgetary allocations, and indeed, funds have so far been spent on the program. The children already enrolled in the CBC system have advanced substantially in their study as well as age. Notably, CBC has been rolled out in all public schools in the country. Stopping implementation as sought by the petitioner would only serve to wreak havoc and cause disorder in the country's education system. This will ultimately be very prejudicial and have a disproportionate effect on the children and the parents. It will offend the right to education and the best interest of the child principle. Overall, this would be against the public interest, and the balance of convenience tilts towards maintaining the system. The present circumstances demonstrate the relevance of the doctrine of proportionality. This doctrine is a legal method used by courts, typically constitutional courts, to decide hard cases, which are cases where two or more legitimate rights collide. In such cases, a decision necessarily leads to one right prevailing at the expense of another. In order to decide such cases correctly, the court must balance the satisfaction of some rights and the damage to other rights resulting from the judgment. The next issue would be whether the grant of the order sought would cause irreparable damage to the respondents, N1GCO, altogether owing to the public resources already used. Specifically, as at 11th November 2021, Kenya shillings 77 B 163 487 and 960 had been appropriated by CBC for CBC implementation, and Kenya shillings 8 billion had been used to construct junior and secondary classrooms in each public secondary school. Granting the orders as sought will lead to a wastage of government resources and taxpayers' money, which will lead to a colossal loss of public funds. This will ultimately offend Article 232 of the Constitution. In addition, the fourth respondent, in a bid to further implement the CBC, advertised thousands of vacancies in its advert of 22nd December 2022, where it sought to employ 9,000 secondary teachers, 1,000 primary school teachers, 21,550 teacher interns for junior secondary schools and 4,000 teacher interns for primary schools. Granting the orders as sought in the circumstances will amount to a loss of employment, as well as wastage of all the resources that the government has invested in rerouting, retooling, and training the teachers.
Places at risk the child's well-being, education, physical or mental health, or spiritual, moral, emotional, or social development. Further, Section 2 of the Employment Act 2007 defines worst form of child labor as follows, I quote, worst form of child labor with respect to juveniles means their employment, engagement, or usage in any activity comprising of all forms of slavery or practices similar to slavery, such as the sale and trafficking of children, debt bondage and serfdom, and forced or compulsory recruitment of children for use in armed conflict. The High Court in JMA, a minor suing through the uncle, and Fred, AAM, versus Paul Jogo Kihara, 2005, Kenya Law Report, at paragraph 5, observed as follows, I quote, I am of the belief that both parties are misconceived in this suit as to the legal issues in question. This suit is really one concerning tort under the common law. It is not a matter of whether the defendant had ordered the minor to work or not. To my mind, there is nothing wrong for children to work to earn a vocation during their spare time in order that they become responsible citizens. A child who works does so as part of her or his education, where on the other hand, the work exceeds the children's rights to education, to play, and the rights to their basic rights, then this becomes child labor, and as such, whoever is responsible should be compelled to stop, and if they don't, are to be punished. End of quote. What the petitioner describes as child labor, in the court's view, are activities that CBC has adopted so as to enable the respondents to promote, protect, and fulfill the right to education for the child towards the realization of Articles 43 and 53 of the Constitution, as well as the state obligations as set out in Vision 2030 and the East African Treaty insofar as preparing the children for the labor market is concerned. From the material placed before court, we are satisfied that the shift to CBC is necessary in the evolving technological and industrial advancements to ensure that necessary relevant skills are imparted on the learners. It is this court's finding, and we so hold, that no evidence has been placed before us to demonstrate that CBC constructively designates children as recruits for casual labor. Whether the materials used in CBC are a threat to the environment, the petitioner accuses the respondents of introducing and implementing a system and structure of education under the CBC which requires single use of course books per child per grade, thereby increasing the risk of environmental degradation in contravention of Articles 21 sub-Article 3, 42, and 69, 1G and H of the Constitution. On the part of the first respondent, it is deponed that heads of institutions are guided within the provisions of the instructional materials, voted on how to purchase appropriate covers which can protect the textbooks from wear and tear, ensuring that they are covered until they attain the 4 years bookshelf life and beyond. It is urged that the books are biodegradable and that schools have been working with industries which correct old books and recycle them. Further, that environmental conservation is one of the areas that learners are being taught under CBC. The burden of proof was on the petitioner to demonstrate that the course books were a threat to the environment. No evidence whatsoever placed before us in this regard, and the petitioner therefore fails to prove this lib. Whether the CBC amounts to discrimination against children, subjects them to torture, and takes away their freedom of expression. Upon perusal of the documents before us, the court is invited to interrogate whether or not the vocational education and training adults in vocational approaches conceptualized for specific use in training adults in Kenya as introduced in the education system in the form of CBC amounts to discrimination against children or subjects them to torture and takes away their freedom of expression. Besides making the above allegations, the petitioner was expected to avail evidence in support, which he has not done. Therefore, the allegations remain bare. Whether Dr. Fred Okengo Matiang'i and Professor George Albert Omore Magoha contravened Section 41 of the Basic Education Act and violated the Constitution. The case against Professor George Albert Omore Magoha has been withdrawn as the 8th respondent is now deceased. It is the petitioner's case that the 7th respondent was the cabinet secretary responsible for matters relating to basic education during the material time. It is contended that he has denied, violated, infringed, and further contravened the Constitution of Kenya insofar as the rights of the children to education and free and compulsory education is concerned by his failure to comply with Sections 39, 41, 73, and 74 of the Basic Education Act, and further that he has contravened Articles 2, Sub-Article 1 and 2, 3, Sub-Article 1, Article 10, Article 53, Sub-Article 1C, 73, 75, 95, Sub-Article 3, 153, Sub-Article 4A and B, and Article 232. The 7th respondent in his reply maintained that he is wrongly enjoined in this petition as he has no personal interest and or desire, independent of the duties vested upon him and which were executed in his capacity as Cabinet Secretary and in compliance with the Constitution. He urges that the Basic Education Act does not purport to set out a specific and precise education structure which cannot be altered or changed. He denies any constitutional violations on his part. Article 236 of the Constitution provides as follows on public officers. Protection of public officers. A public officer shall not be victimized or discriminated against for having performed the functions of office in accordance with this Constitution or any other law, or be dismissed, removed from office, demoted in rank, or otherwise subjected to disciplinary action. Officer appointed under this Act shall, if done in good faith, for the purposes of executing for any action, claim, or demand. It is clear if done. This court takes judicial notice of the fact that despite the 7th respondent's involvement in the initial stages of transition as a person has not been established and or proved to a degree of certainty, and we would be reluctant to visit any censure or sanction on him. Implementing the CBC, in his petition, the petitioner seeks for injunction and conservatory orders against further implementation of CBC. The principles applicable in the issue
of interim orders in our human rights enforcement architecture. Article 23, sub-article 1 of the Constitution provides that the High Court has jurisdiction in accordance with Article 165 to hear and determine applications, redress of a denial, violation, or infringement of or threat to a right or fundamental freedom in the Bill of Rights. Article 23, sub-article 3 of the Constitution provides that in any proceedings brought under Article 22, a court may grant appropriate relief, including A, declaration of rights, B, an injunction, C, a conservatory order, D, a declaration of invalidity of any law that denies, violates, infringes, or threatens a right or fundamental freedom in the Bill of Rights and is not justified under Article 24. E, an order for compensation. F, an order of judicial review. The Supreme Court further had occasion to consider the scope of Article 23, sub-article 3 of the Constitution, as read with Article 165, sub-article 3D of the Constitution, in the case of Communications Commission of Kenya and 5 others versus Royal Media Services Limited and 5 others, petition number 14, 14A, 14B, and 14C of 2014 as consolidated. The court stated as follows: a close examination of these provisions, that is Article 23, sub-article 3, and Article 165, sub-article 3D of the Constitution, shows that the Constitution requires the court to go even further than the U.S. Supreme Court did in the Marbury, and that Article 23, sub-article 3, grants the High Court powers to grant appropriate relief, including meaning that this is not an exhaustive list. Further illumination on the matter is found in the case of County Government of Kilifi versus Ethics and Anti-Corruption Commission, where Justice Odunga has in 5 steps. 1. The first step involves the court identifying how a particular right has been violated or how the government has failed to honor its obligation in regards to the right and making a declaration to that effect. 2. The court compels the government to comply with its constitutional responsibilities. 3. Involves ordering the government to submit a comprehensive report under oath detailing the ways it will remedy the violations in question. The government tables the report before the court by a specified date. The plan itself should also bear the timelines for achieving various milestones identified within it. 4. The court evaluating the plan before it and weighing whether or not it adequately remedies the situation. This stage intertwines the judiciary and the other branches of government in the implementation of policies. 5. This stage comes in when the government fails to adhere to the plan in place, which amounts to contempt of court. In prayer number G of the petition, the petitioner sought the following: an order be and is hereby made directed to the first and second respondents to draw regulations in respect to policy and guidelines on a curricula in accordance with sections 73 and 74 of the Basic Education Act, number 14 of 2013, and section 4 of the Kenya Institute of Curriculum Development Act, number 4 of 2013, respectively, and table the same before the 6th respondent for approval within 90 days of the making of the order in that regard. On our part, recognizing that regulations under Section 73 of the Basic Education Act have not been made, and in order to ensure standards, quality, and relevance in curriculum development is continuously developed, reviewed, evaluated, and monitored, the court holds the view that an order is necessary to ensure such regulations are in place. Further, that we interacted with the reports of the Presidential Working Party on Education Reform, from where we noted that there were numerous recommendations on the education sector with specific timelines for implementation. We are satisfied that the recommendations, if implemented, would impact positively on the CBC system and the education sector generally. In that regard, we are minded that an order is necessary to ensure the implementation of the recommendations, necessitating monitoring, evaluation, and implementation of the report. The court further notes the need for capacity building and awareness creation on the recommendations as generated by the report on the Presidential Working Party on Education Reform. Following the above, we make the following orders. From the material placed before the court, and for reasons above stated, it is our finding that the petitioner has not proven his case to the required degree, and we so hold. The following orders shall issue. 1. The petition dated 16th of September 2021 is hereby dismissed. 2. The first respondent to initiate the process of amending Section 41 of the Basic Education Act to align the structure of education with the CBC within 120 days. 3. The first respondent shall make regulations as demanded of him by Section 73 of the Basic Education Act, number 4 of 2013, within 120 days. Number 4, the first respondent shall set up a committee to ensure the implementation of the recommendations of the report of the Presidential Working Party on Education Reform dated 9th June 2023 within 90 days of today's date. We make no orders as to costs.
All of you have picked up a nice thread of being grateful. Rarely do we get that, so we are also grateful.
So you have to. The order that were never played in the petition.
No, you ask me questions, then I'll tell you. Well, today, the bench of 3 judges that was given the heavy responsibility of determining the future of the education system in Kenya has given a decision in which they dismissed the petition that had been filed by us. The dismissal was based upon a finding made at the initial stage of the delivery of the judgment, that there was no evidence to support the petition. Quite weird finding by the court, bearing in mind all the evidence that was before the court. But the peaks from these decisions are two. The minister in charge of education has been directed to pursue the amendment of the Basic Education Act so that they can domicile the CBC system, as well as formulate regulations to support the system of education. The committee that had been appointed by the president to look into this issue has also been directed to facilitate the implementation. I've told the court that we will not appeal. I will tell the Kenyan public that we will not appeal. Perhaps it is time we left the Kenyans to their own fate, because, look, such struggles end up in this type of outcomes. But perhaps we should not be wasting time fighting for the rights of Kenyans. I look forward to, it's called what, Generation Z or Z? Perhaps Generation Z can find a better solution to this problem. On our part, we've done what we could.